All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Well, welcome back. Carl Rominger here, 540-0580. I've got Attorney James Demmel here on the phone. How are you, James?
Hi, I'm fine, Carl. How are you?
Good. Can you introduce yourself a little bit? Tell us a little bit about you and what you do, and then we'll go into collaborative law.
Sure. I'm Jim Demmel. I'm an attorney in Harrisburg at Smigel, Anderson, and Sachs. I practice family law. It's 100% of my practice. I went to law school a little later in life after getting my master's degree in psychology. Went back to law school, graduated in 2003, and have been practicing since that time.
I'll say that the master's degree in psychology makes you suspicious, but other than that, sounds like good credentials.
Well, thanks.
And now you are involved in a process, and I don't know if that's the right way to describe it, called collaborative law, and also involved with an association of collaborative professionals. So let's just talk about collaborative law generally.
Sure. Collaborative law, you are correct. It's a process, just like any other process that you're going to go through to resolve any family law conflict, be it a divorce or custody issues or support.
Mm-hmm.
And collaborative law is based on the idea of the parties and their attorneys working together to reach an agreement.
Mm-hmm.
The entire premise of this process is that the parties and their attorneys are committed solely to reaching an agreement. They agree from the beginning that they're not going to litigate, they're not going to go to court. That is taken off the table for the duration of the collaborative process. The attorney's role is to represent their client in this process and give legal advice, and also to facilitate the communication between the parties, to help them have the conversations they need to have to decide what they're going to do as far as dividing their property, how they're going to deal with financial issues and support and income, and how they're going to arrange a schedule for their children to spend time with both of them.
Now, the question would be, how is that different than what lawyers have traditionally done in the context where it's not unusual in a regular, say, custody case for the parties to get together and do a four-way conference, or in a divorce, the parties to get together and do a settlement conference? I mean, how is it different?
One way it's different is the commitment from everybody involved, the parties and the attorneys, that they're not going to court. There's no backup that we'll sit and talk about reaching an agreement, but if that doesn't work, well, we'll just file a petition with the court. We'll, go to a custody conference with the court or go to a hearing.
Like when I throw my pen down on the pad and go, fine, if you want to do it that way, I'll just take you to court.
Exactly.
That's been removed.
That is removed. It's gone. And the attorneys commit from the beginning of this process that if either party decides to leave the collaborative process, both attorneys are disqualified from representing either of the parties.
So basically, well, I mean, now let's talk about that for a second. So the dynamic is that if either party decides to leave the collaborative law process, they're going to lose the attorney they've been working with.
Correct.
And the other side is going to lose their attorney as well. And it's going to become a more traditional case, but they're going to have to start from scratch.
They're going to have to start with new attorneys.
Okay.
Not necessarily from, point zero, since they're wherever they are in the process of gathering information
right.
and those sort of things. So, they pick up where they left off. But they definitely would have new attorneys and would be in a completely different process.
And so my question would be, okay, if I come in to see you and I say, hey, Jim, listen, I want to get a divorce. I want to get into this collaborative law thing because I've heard it's easier and cheaper. But I'm not that committed to it, but let's just give it a try. I mean, how do you balance that out when you're agreeing to take a client in the collaborative law process? I mean, how do you know you don't have somebody just trying to game it, or what level of, how do you look for a level of commitment there?
Well, one thing I tell people in the first conversation I have with all of my clients is, if you're going to get divorced, how are you going to do it? And here are your options, so that they can understand that there are different options as far as how to do it. If they want to use the collaborative process, we talk a lot about why that is. If it's just to possibly save money, if it's just to possibly make things go faster, that's really not enough. And I'll emphasize to them that that's not the biggest part of committing to this process. You really have to be committed to reaching an agreement by taking your spouse's needs and interests into consideration as you're going through this process and making decisions.
And we're going to go to break in a few minutes. When we come back from the break, I'm going to want to talk to you a little bit about, because I think this is where this kind of segues into. And I'm going to want to talk to you a little bit about how the collaborative law process influences long-term outcomes, because I hinted at that earlier hour when I said I was going to have you on, that sometimes it's not about saving money, it's about saving the emotional toll and wreckage that a true adversarial process can create. I don't want you to answer that yet, but I just want you to think about it.
Okay.
We'll go to break in a couple minutes, I guess. But in the other question then would be, I guess, you have to then, so I come to you and I say, I want a collaborative lawyer. And I'm committed, and you talk to me and I seem like I'm capable of it. How do we get my wife into a collaborative lawyer at that point?
Part of what I would explain is we need to have a collaboratively trained attorney on the other side representing your wife, and would recommend that we get information to your wife about the Collaborative Professionals of Central Pennsylvania,
right,
which is our local practice group. I'm currently the president of the group, and one of the reasons the group exists is to be a resource for individuals who are looking to get information about the collaborative process and to hire a collaborative professional. So we refer within that group, we provide information regarding other members of the group so that the spouse can go meet with one or more other collaboratively trained attorneys and find out for themselves.
And do you see this sometimes where I come in and I say, okay, I'm good, and we're good, and I give the literature over, and then the other collaborative attorney calls you up and says, listen, I met with this person, it's not going to work. They're not going to be able to make the level of commitment we're going to need to this process.
There are times when that happens, yes.
And then I assume you give me the bad news and say, now, at that point, though, here's my next question. We haven't really done anything yet. Could you then just be my non-collaborative lawyer?
Yes.
Okay.
I could. Until the first step in the actual collaborative process, at our first meeting, we sign a participation agreement. Both parties and both attorneys sign an agreement committing to the collaborative process and the restrictions that process involves. At that point is the commitment from everybody.
But up until then, we're free. In other words, I don't have to give you up as my lawyer at that point. We just would maybe handle it in a non-collaborative shell.
Correct.
Interesting. Yep. Jim, I got to go to break here. When we come back, I'm gonna hit you up with that question again.
Okay.
That I told you to think about. All right?
Great.
More than just D580.
Welcome back. Carl Rominger here. I've got Jim Demmel of the Collaborative Professionals of Central Pennsylvania joining me, talking about collaborative law. And as I'm understanding it, collaborative law mainly tracks in the divorce and domestic custody type law. Is that a correct statement, or are there other areas of law that have become collaborative as well?
There are. It can certainly be applied to other areas of the law. Primarily in central Pennsylvania, it has been used in the family law area. In other areas of the country and the world, actually, it's been around a little longer and has been applied to other areas as well.
I can see a lot of natural fits, for instance, for these neighborhood disputes. You know, my fence is in your yard. Things where you have two people who have an issue that could probably be quite often dealt with by some kind of mutual understanding as opposed to some ultimate verdict.
Absolutely, especially where the parties are still going to be tied together afterwards. They're not strangers who were in a car accident. And
that's exactly kind of why I asked you what I did before the break, and the question was involving the idea that you might not, a particular collaborative law case might or might not be cheaper than doing it through an adversarial means. Who knows what any one particular case is going to cost? I mean,
correct.
But at least on the emotional side, if I go to court and call my ex a heroin dealer and she calls me a cad and we go back and forth for a while, everybody leaves with some hard feelings.
Absolutely.
I'm assuming that part of the process of the collaborative law, or part of the thesis of the collaborative law process, is that by, and as you said earlier, taking into account the other side's needs, wants, viewpoints, the two sides can come to a resolution right from the beginning where they're learning how to maintain that long-term attachment, particularly in a custody case.
That is one of the huge benefits of the collaborative process. We've seen in litigation what happens when parties are testifying in a custody action or a divorce action, and you can't take those things back. Once they're out there, you can't take them back. A big part of the collaborative process is preserving that relationship between parties who are still going to be tied together, especially if they have children, for the rest of their lives, and helping them resolve their disputes in a respectful way that really concentrates on both of them, not continuing the acrimony between them, but helping them to understand each other a little bit better. Now,
my follow-up to that question then is, because that seems to make sense, but one of the things that I always like to say is, and Ronald Reagan borrowed this from me, trust but verify. Do we know, has anybody done any studies to see, for instance, that couples who went through a collaborative custody case have less, what would we call it? I don't know if we call it recidivism or not, or less later custody disputes? Do we know about the outcomes? Is there any studies or research out there?
There has been research done by the International Academy of Collaborative Professionals, who have actually looked at the results in collaborative cases and done surveys of the parties who participated. And their research shows that there was the vast majority of participants in the collaborative process said that they were satisfied with the outcome and that they would go back to the collaborative process if disputes arose in the future that they would need to resolve, which I think is probably the biggest endorsement to the success of using this process.
And I guess there could be an argument made that the type of person who selects collaborative law may be a person who's more likely to be able to successfully negotiate things in the long run.
I would agree with you. I think that's part of determining the correct process for each person, because the collaborative process is not for everybody.
Right.
You have to really go into it with the commitment to reach an agreement. And there are individuals who, for one reason or another, are not interested in understanding the other side any better or reaching an agreement and just want their day in court and their pound of flesh, and they're going to use a different process.
Mm-hmm.
So there is some selection as far as individual personalities, the people who are interested in using this process.
Well, I would imagine that it is difficult sometimes for individuals to truly understand the other person's perspective, because so much of people's perspectives is based on their own worldview, their own experiences, and that's a difficult thing for a lot of people to do. Now, do you find that particularized training, now you have, for instance, a background in psychology, do you think that the lawyers who do this need to have a special sensitivity to help the clients get to that area?
Well, we have in our Central Pennsylvania practice group, we require the basic collaborative training. We also require mediation training, which is very helpful in helping parties better understand the other person's perspective. In addition, we recommend in every collaborative case that the parties work with a coach. And a coach is a mental health professional who is not there to provide therapy and is not there to try to get the couple back together, but specializes in helping them with their communication.
Okay.
And that person is an expert in that area. We have, as attorneys, we have some additional training, going into the collaborative process, but that's not our area of expertise. So getting an expert involved from the beginning who can help the parties communicate is really key. Okay,
so that's a component that's different than the lawyers. It's going to be somebody, like you say, mental health professional, some sort, whose job it is and is that done as kind of as individual sessions or like a joint session between the two?
Usually what happens is the coach will meet first with both parties and then have one individual session with each party.
Mm-hmm.
And then they'll decide from there with the coach and with the attorneys how much they want the coach to be involved. Sometimes the coach will be involved in all of our meetings, and it'll be the two attorneys and the parties and the coach. Sometimes the coach will be in the background, maybe meeting with the parties in between our four-way meetings, and sometimes just sort of there in case any problems arise,
mm-hmm.
they can step in and lend a hand to help us through those things. So it really depends on a case-by-case basis.
And I would imagine, again, it just comes back to the individual parties. I'm sure some people are much more capable of understanding the other side's position or at least reaching reasonable compromises with less intervention, and some need a lot more.
Correct. Yeah, It's a very individualized process.
Now, of course, then I could go, well, how much does this cost? I mean, if I'm out there listening in listener land right now,
yes.
We've got all kinds of listeners. We've got listeners that could probably buy and sell the radio station, and then the rest of the listeners are more like me. We're going to be able to maybe buy the microphone and the earphones, but not the whole radio station. So, what are we looking at? And I don't want to put you on the hot seat here. I don't need an exact quote, but I mean, how does this compare? I mean, sometimes you can get in and out of custody court for $1,000. Sometimes it's $100,000. Where's collaborative law on that scale?
In general, when they've looked at the cost of the collaborative process versus litigation, the collaborative process is generally less expensive.
Okay.
I never tell my clients this is a less expensive process because you don't know what would happen in the alternative.
Right.
But what the parties are doing in the collaborative process is really using their attorney's time and their time and energy and their money to pay their attorneys as effectively and as efficiently as possible. Because the only thing we're working towards is reaching an agreement. Right. We are not filing anything with the court. We're not filing petitions and answers and sending letters back and forth. We're not doing formal discovery. Everything is voluntary. Everybody agrees from the beginning. They're going to voluntarily provide all of the information that's relevant to making decisions. And we eliminate a lot of the processes that go on in litigation that may be necessary in litigation, but aren't really geared towards reaching an agreement.
Okay. And what I want to do, I'm going to have to go to break here again in a second. When we come back, I want to talk to you a little bit more about the process. I want to talk to you a little bit more and let you see what else you want to tell us. But I also want to invite callers, 540-0580. If you have a family law question, Jim is uniquely qualified to answer it both because he can do regular family law and also collaborative family law. And maybe we can look at these questions in the context of both approaches and see what kinds of answers we come up with. But I would like to invite the listeners to join us. I'm sure you'll be happy to answer a few of their questions. And, of course, if they want to go off topic, I'll just hang up on them.
Sounds great.
All right, 540-0580. Call in, guys. We'll talk more with Jim after the break.
When news happens, we break in. Central Pennsylvania's news leader is...
Welcome back, guys. Carl Rominger here, 540-0580. 540-0580 is the talk line number. I've got Jim Demel on. We've been talking about collaborative law. It's a family law process here in Central Pennsylvania. He's the president of the Collaborative Professionals of Central Pennsylvania. And obviously, Jim, while I've got a chance, if people wanted to get in touch with you, how would they do that?
I can give you our website for the Collaborative Professionals of Central Pennsylvania.
Okay.
Which has some great information on it. It is collaborativelawpa.com. It's collaborativelawpa.com. That is our practice group's website that has information regarding collaborative practice. It has information regarding all of the professionals who are part of our group.
I'm going to post that actually on my Facebook page as well so that folks can find it there. So just a little hint in case you're listening and know where to look. Basically, that's going to help them find out about the practice group, who's involved, give them a list of practitioners and how it works so that they can kind of pre-screen themselves, right?
Exactly. Yes. The biggest thing people can do if they're going to be going through a divorce is educate themselves about what their options are. The more information you can get, the better informed you're going to be to make a decision about how you're going to go through this.
Now, in terms of the collaborative law process, and we've been talking about the less of an emotional toll. We've been talking about how it works a little differently. Can you think of any particular success stories you've had that you could illustrate?
Well, I've had numerous couples I've worked with who, as we went through the process, had their difficulties. It's certainly not always cheerful in the meetings, and we're still dealing with some pretty heavy topics, big decisions that have to be made. But afterwards, it's pretty much unanimous that people thank me for what I did and for helping them and for being involved, which to me is very rewarding that, my time, the money they paid to me, actually helped them to get through this. One particular case was, I think would have been a real nightmare in litigation, dealing with probably business valuations and financial experts and a real contentious divorce.
Right.
I think it could have been. But through the collaborative process, we worked with one financial professional instead of the dueling experts. We worked with basically an open book as far as the husband's business, and really streamlined everything to get to the point where they both understood what we were looking at in considering his business in the divorce process, and saved them, I think, a ton of money in the process, and also preserve their privacy, which to me is a big benefit. This is a private process. The court's not involved. There's no record for anybody to be privy to. And in this case, the husband's business was kept private from anybody who would have been curious about it in the divorce process.
And that alone, that anonymity or the ability to keep those things out of the public record is obviously a great advantage.
It is. It's. I don't know that anybody wants their dirty laundry, their private lives, aired through the court system, and to realize that all becomes a public record.
We had a case one time where somebody had done something very, say, embarrassing, and I remember my then law partner saying to me, "Think of the most bizarre thing you've ever done, and imagine everybody found out about it."
Yes, yeah, and we learn. I mean, as family law attorneys, we learn the intimate details of our clients' lives. We hear about everything, much more than probably anybody else in their life knows besides their spouse. Right. And protecting that, I think, is really important.
And Jim, I just want to remind people the number is 540-0580. If you have a family law question, now would be a good time to shoot. You got two family lawyers on the radio. You can get your, and obviously you're much more specialized than I am in family law. I seem I dabble in that, along with a little criminal law and a little personal injury and a few other things. But this is a good chance for anybody out there, 540-0580, to get two opinions for the price of one. And in this case, it's free. So I'll invite them.
It's a good price.
I guess the other question from a collaborative law standpoint would be: have you seen cases blow up, and what happens when it does? I mean, how hard is that? Any follow up after that? The client has to dump you as a lawyer at that point, right?
They do. I've had unsuccessful cases where they didn't reach an agreement, an overall agreement at least, in the collaborative process. Mm-hmm. They may have reached some interim agreements that they stuck with, even though they were leaving the collaborative process. But my experience in those cases was also that the parties, even though they had decided to leave the collaborative process, whether it was both parties deciding they just weren't going to reach an agreement, or one party deciding that the process wasn't for them, we still were able to make it an organized change. Mm-hmm. And the attorneys in those cases, myself and the attorney on the other side, were able to work with the parties to say, okay, if you're leaving the process, it doesn't need to be a free-for-all here. We can do this in an organized way. And, actually met with them to decide what they were going to do, what timeline they were going to use. And we each gave them referrals to other attorneys,
right,
to talk to. And even made that process, I think, better than it could have been.
I guess the other question is, time frames, because there's a little bit of a dance getting the collaborative law process set up. Like we had a caller earlier today, and it sounds like an emergency custody matter. Can collaborative law help with an emergency custody matter, or is that something where the parties are going to have to do some initial a traditional litigation because of the time frames involved. And I guess maybe if there's an emergency custody matter, maybe that suggests that one or more of the parties isn't quite ready for a collaborative process.
Well, that may well be. If you have a situation where one party has left and taken the children and won't give the spouse any information about where they are and those sort of things, they're probably not an ideal candidate for the collaborative process.
Right.
Unless there's something missing that we don't know. There could be some additional facts here, but we can, in our first meeting, deal with any immediate concerns
right.
that they have. And we often deal with the financial issues. How are we going to, in the meantime, while we're in this process, how are we going to pay our bills, make sure that that's taken care of?
Mm-hmm.
And we get that out of the way so that it's not hanging over everybody's head. Immediately we'd like to come up with a schedule for our children so that we're not anxious about that. And we'll deal with that first in our first meeting, and we'll usually get that out of the way. And then we can relax about that and move on to the financial issues.
And I know that's sometimes my joke with the staff is you've got to get people on the phone right away or with the attorney on the phone right away when they call in, because a lot of people, those immediate concerns are what are driving them, and they need to at least talk to somebody to say, just because somebody's filed a divorce complaint and it says that if you don't answer within 20 days, you're going to lose important rights, it doesn't mean you literally have to answer it today. You've got a few days to get everything together, meet with somebody, and figure it out. There does seem to be a lot of anxiety on the front end for people on how are the little things going to be taken care of, let alone the big things immediately.
Absolutely. Yes, we have, when somebody first contacts you, there are those things that are keeping them up at night. And usually with a phone call, you can alleviate some of those concerns, really knock down that anxiety level, and then have them consider how they're going to go through this.
Mm-hmm.
And realize that these scenarios they have in their head of what could happen probably are not realistic.
Right.
And they need to hear that from an attorney who, can really give them that assurance and explain things to them.
Jim, I got to take one more break here. When we come back for a break, we've got Josh hold on the line. We'll see what question he has for us.
Okay.
All right, see you in a minute.
If it matters to you, it matters to us. Carl Rominger on WHB 580.
Carl Rominger back here, 540-0580 is the talk line number. I'm talking with Jim Demmel. He's a collaborative lawyer, and he's the president of the Collaborative Professionals of Central Pennsylvania. We've posted their website to my Facebook page. But, Jim, the website again for people who might want to check you out is?
It is collaborativelaw.pa.com.
And, by the way, folks, collaborative, just so you're wondering, because I couldn't spell it. I got spell checkers. COLLABORATIVE. It's one of those words, you want to mix the A's and the O's up in. So that's why I throw that out there. I'm sure everybody else can spell and I can't, but that's just the way it is. 540-0580. Josh, you're on with Carl and Jim.
Yes, hi. Thanks for taking my call.
No problem.
I have a question about child support and seized bank accounts.
Okay.
Right. I was divorced several years ago, and I was working several jobs to make sure the child support was taken care of. I lost 2 of my 3 jobs at the point, and the child support fell into arrears. And so, of course, domestic relations seized the bank account. But now that my income is more stable, I have more income coming in, and the bank account is still seized. All of my checks are going into direct deposit, and it's way more than enough to take care of child support. They're still taking all of it, and I'm not even able at this point with the seized bank account to write checks to domestic relations to take care of the child support. So I guess my question is, because I have to admit, I'm a little bit afraid of the whole domestic relations department.
Right.
How do I go about communicating with them to let them know that with my current level of income and direct deposits, if they take the maximum of 55% of that income, it'll be more than enough to take care of child support to release the seizure on the checking account so that I can go ahead and continue with daily life, daily business.
Well, I mean, the answer there is I would think if you're afraid to talk directly to them and you're not sure how that's going to go, you might want to have a lawyer in between to mediate to see what their position is. Jim, what do you think?
I think I don't know that the outcome could be any worse than it is now. What else are they going to do?
Right.
There should be a conference officer who handles your domestic relations case, and you should be able to contact the domestic relations office, get in touch with that conference officer, and explain the situation. They, I'm guessing, may have done this, seized the account, and never really looked at it after that. So they're probably not even aware of what the situation is. So contacting them and explaining the situation and having your wages attached so that the support's coming out of your wages may be a pretty straightforward process. I understand your reluctance to get involved with the domestic relations office, but I don't know that the outcome is going to be that bad.
And Josh, it sure seems like they already know where you are.
Well, they do know where I am. In fact, I've met with the enforcement officers in the past, and we took a look at the wages and what was available for child support, and 55%, the maximum percentage allowed they could garnish on my wages, was more than enough to take care of the child support. And that was some time ago, and they actually didn't follow through, which led me into this arrears situation. And my hesitance to walk into the domestic relations office is, you go through a security checkpoint, you end up in an office in a secluded and secure room, and it feels like you're in a very dangerous space where you owe so much money in arrears, and you've heard horror stories about, you haven't paid, so we'll take you away. And I have to admit that's a part of my fear, but it's all clear and understandable. But I'm concerned and there's really no way to directly contact domestic relations by phone or by email or any other online.
You should be able to get an email for the conference officer, but the short answer is, sometimes the old song says, send lawyers, guns, and money. Well, in this case, you need at least a lawyer. Probably money would help. All right?
That would be great. Thanks
All right,
so much
thanks.
for your time.
I don't know, Jim. I mean, the answer there is you got to deal with it, and sometimes putting a mediator or a buffer in between, if you're afraid of them, that may work well.
I agree. And somebody who is used to dealing with the domestic relations office, it may be really no sweat for them versus it's a really intimidating process for somebody who, like Josh, who,
Yeah, he hasn't had a lot of positive experiences with him at this point, and and then their defense, he hasn't paid, so that's probably why they're not making it the kindest or gentlest experience.
It's not a gentle system.
They call you a customer, right? Here's your customer number, but it's not. The customer's not always right when the government's involved. I'm gonna just turn tax on you for one quick second. I only got about 2 minutes left, and I want to really thank you for coming on, Jim.
Well, thank you for having me. I appreciate it.
Did you see that the federal court struck down the Defense of Marriage Act?
I did.
There's a First Circuit decision, but they're basically inviting the Supreme Court to weigh in.
They are.
So I hope the listeners will pay attention and keep your eye on that, because I think that's going to be major news for us.
And one other aspect of the collaborative process is that you don't have to be married to use this process like you do with a divorce in court. It can work really well for unmarried couples who are married in all but name,
right,
and have all of their finances intertwined, or same-sex couples who, their relationship may be ending and they can't go to the court, they can't get a divorce, but they still have all of those things to deal with that a married couple would need to deal with.
Right. Interesting. And that's a good point, because in that case, neither one of them really has the hammer of the court available, so why not use the system that's been perfected to remove the hammer of the court?
Exactly.
Interesting. I guess that's good. Then maybe I can get my lady friend in and get some support out of her. But yeah, no, again, I want to thank you, and I want to remind people, Jim is the president of the Collaborative Professionals of Central Pennsylvania. He's an attorney. He practices family law. You're over with Smigel, Anderson, and Sachs.
Smigel, Anderson, and Sachs.
That's my good friend Fred Hates running around there, I believe.
Yes, he is.
And a very good firm in all areas of the law. I have to say that. I hate to say that, right? But I have to say that.
Thank you. I'd like to give you one other website, Carl.
Yeah, go ahead.
Which is PADivorceLawCenter.com. And that website is for the Family Mediation and Collaborative Law Center, which was started by myself and my partner, Ann Levin. And that website also has some excellent information about the different options if you are...
And it's what, PA?
It is PADivorceLawCenter.com.
I'm putting that up on the Facebook as well. I'm out of time, my friend. Thank you very, very much. Jim Demmel, thank you.
Thank you for having me, Carl.
All right, take care.
You too.
Guys, I'll see you next week, I think, depending on how busy I am.